Hi there, I'm Stephanie Robinson from HR Solver, and in this video I am going to break down exactly how you can write a really compelling appeal letter against your redundancy or disciplinary decision. And I'm also going to explain why it's really important that you do appeal. And let's face it, it could be affecting your life and your income for good if you have now been dismissed. I've helped lots of people make the necessary steps to go through with making an employment tribunal claim. And there are 3 students in the last couple of months that we've worked with very closely who have followed the steps in the training, the advice I've given them, and they've walked away with over £40,000 worth of compensation from their ex-employer. One employee was given an initial offer of £7,000 and we managed to get that increased right up to £20,000. They've also avoided the pain and emotional strain of going through an employment tribunal through going through this kind of quite laid out strategic process to make it clear to the employer that you're prepared to fight and that you do want to go forward with an employment tribunal claim. You don't need a lawyer. You do not need to spend thousands of pounds. You just need some tenacity, some basic knowledge of employment law, and a great teacher. Now, I know I would say that, and I'm being quite cute, and I would also wink if I could right now, but I can't. So let me get on and talk about how you can stand a chance of winning an employment tribunal on the basis of your appeal. So do you know that you do stand to lose or gain 25% of any award made to you, depending on whether you have appealed or not? This could mean £2,500 either way, basically by adding to the average award of £10,000 for an unfair dismissal claim. And that's not including discrimination, which could go much, much higher. But say you got an unfair dismissal claim award, you could get £12,500, or it could be reduced to £7,500 because you've not appealed. And it is worth appealing because actually many companies get that appeal management piece wrong. And that's why there is this 25% award uplift for people, because very often employers are failing to allow them to appeal and then failing to follow up a fair appeal process following that ACAS code of practice. So if you're following my point here, please stick 25% into the comments below so I know that I have explained it okay. It'd be great to know that I'm making some progress. It's also just to point out that it's just too common that employers just don't train their management on appeals and they get it wrong when it comes to listening to the appeal. And really, I just want to stress that for me, it's really crucial, the appeal, because at the end of the day, if there's been a botched investigation and a botched disciplinary and they've rushed through it and then the appeal is botched, that could mean that you can't pay your mortgage, you don't have a job anymore. And this just gets too easily forgotten by people in big companies in management, and they're tasked as appeal managers. You're forgetting the actual impact on people that losing a job could mean. They forget as an appeal manager that their role is really to ensure that a fair process has been followed and not the company agenda. And sadly, people that have lost their jobs mean that they're at a total loss. They feel that they struggle mentally as a result, that their sense of self is diminished, that they then have shame and they have a trauma associated with being in work. It can spark a spiral of depression, relationship breakdowns and worse. And really, for me, it should not be like this for people. Appeals are therefore a fair review of the facts, and you should appeal for that basis if nothing else. And I have seen these botched investigations because employers just don't really understand what a really good investigation looks like. They're not willing to be fair. They've already made a preconceived decision because they didn't really like that person anyway, or they're too expensive. And I have wasted thousands on legal fees to discover that it has been a waste because it's not got me any further. And really, my view is that at this stage, it's probably still a bit early to instruct any solicitor, but you still need good advice. And that's why I have established HR Solver, really just to have that playing field evened out a little bit, have resources, many of which are free, everyday people to help them prepare for meetings, get them on the route to a compensation and rebuild your life, even if that means that you're saying goodbye to employment forever and setting up your dream business or your dream property empire. But in this video, I am going to teach you, as I've promised, how you appeal a decision on a dismissal or redundancy, because even if it is just for case building, for financial reasons, it's worth doing and it's worth doing properly. And I'm going to give you an overview how to build that case and what to include in that letter through creating sections and headings, and also discuss what points to make if it's the redundancy appeal you're drafting or the disciplinary appeal. And I'm going to talk you through some tips to get into the essence of your appeal case so that you can again articulate that and how you might handle the appeal meeting. So let's go to the first point. When you're brainstorming and drafting your appeal letter, the sections I suggest you include are 2 key headings: the processual issues and a second heading for the decision. By processual issues, I suggest you have subheadings for suspension, timeline problems, investigation approach, and evidence relied upon. And you might actually have these subheadings and then another section for the decision made. And hopefully you'd be outlining in the decision made what you feel was incorrect and disproportionate about the decision. So you might be comparing it to a peer who is also going through the same process. It might be talking to your mitigation. So you might have a subheading of mitigation. And by mitigation, I mean the points that you made in your disciplinary to explain your actions and that there was issues with that case that were given pertaining to your case. And maybe they didn't listen to you, or maybe they didn't consider them, or they didn't give any gravity to those. And then in the subheadings I mentioned, the suspension, you might be talking about how you were suspended, but another colleague wasn't suspended, and how this is materially unfair, and that this colleague therefore had the opportunity to tamper with the evidence or speak to any key witnesses where you did not. And so it's really important that you talk to these points and are specific about how they affected the outcome and the decision made against you. My second point is related to the redundancy appeal, and clearly you don't need to be talking about suspension in a redundancy appeal letter. You will still, and I do encourage you still, to have headings: processual issues, and that might be relevant to and instead of the decision-making heading that we had in the disciplinary appeal, I would substitute that second key heading to the business case for redundancy, because in a redundancy situation you're appealing the process, but you might be also appealing the rationale that the business has supplied for making that redundancy case. So in consultation, the process is quite specific, and if you have less than 20 employees were made redundant, then you need to consider for sure that they have meaningfully consulted with you. Just because there's not more than 20 redundancies doesn't mean that a process shouldn't have been carried out and that nothing was preconceived. Oftentimes employers don't understand this and they just make people redundant without going into proper consultation. And the business case needs to be backed up by the employer in the evidence through the consultation to show that there was a legitimate need for the redundancy business case because the company had explored all other avenues, and that it can't just be purely because the CEO woke up one day and decided that he wanted to make redundancies because people in the business no longer fitted his purpose. They need to show that the redundancy was a last resort and that they reduced all their other financial costs in the business before making a redundancy. This might be slightly different if you're being made redundant because of a restructuring. And restructuring is a change of strategy or circumstances for a business. And it's not necessarily where it's all about the money, but they might be saying in this instance that they're no longer making a product or a service as they had done previously. And let's say, therefore, there's a diminished need for jobs in gluing. And as a result of the change of strategy, they now need more people to be sewing. But clearly, before you're made redundant because you're a gluer, they need to really be exploring with you if you could be retrained or you would consider a job in sewing before you are made redundant for the fact that the gluing job is no longer there. And the key thing to remember is that people are not made redundant. Jobs are made redundant, and the business needs to justify why these jobs are no longer needed, either through a diminished demand in products and services or because they're closing a site, for instance. Now, if you need to know if you have a strong basis for an appeal, and you might be really starting to prepare yourself for an employment tribunal, you can go to the HR Solver website, hrsolver.co.uk, and take an assessment on the website. Or better still, download my totally free assessment checklist, which will help you determine how strong your appeal case is for redundancy or for disciplinary. And I've got you covered in both of those angles, so you can download the appropriate one. The assessment online will also help you either way, and it will talk to both redundancy and unfair dismissal and or discrimination. So moving forward, the key to writing this really comprehensive, compelling appeal letter and to become that thorn in your employer's side, which is where you're really aiming, you want that employer to start regretting getting it wrong, and that you don't need to do that by hiring a lawyer. You just need to know your rights and make those valid points. I do have templates and further advice online that you can download, a training course that just helps you get all that together. But if you just want to do it yourself, totally cool. Follow those headings I talked to you about earlier. Cite the ACAS Code of Practice because it's required in a disciplinary investigation, and the information and consultation legislation for redundancies. But remember to remind your employer of the fairness, independence, impartiality, credible investigation. And if you're not sure what a credible investigation looks like, look at my last video because it'll talk you through exactly what a proper investigation looks like, and it will help you then articulate, having watched it, where your employer went wrong in the investigation process. And it'll allow you to comment, intelligently how you can compare the logic and severity of the penalty of the decision taken against you. And so you're on track for not only acing an appeal letter, but you're going to perhaps get to the stage in both redundancy and dismissal where your employer realises they've made a mistake, they've not done this right, and it's quite hard for them to get every aspect right, bear in mind, and they might be looking at offering you a settlement offer. Not sure what a settlement offer is? Watch this next video where I explain exactly what a settlement offer is and how you can get one and when you can get one. And a settlement will give you some funds and money to rebuild your life. If this has been helpful, please subscribe below. Ask me any questions. I will do my very best to answer them. I will see you in the next video.